Good morning. My name is Kate Grangard, and I am joining you today to present a webinar on distributing the notice of employee coverage options. On behalf of the FIADA, I will be a speaker at your upcoming conference in Orlando. Again, my name is Kate Grangard. I am with the Gehring Group. We are insurance brokers and consultants. I am a CPA by trade, meaning that when the healthcare reform laws came out, I was able to take my experience with understanding the Internal Revenue Service, Department of Labor, Wage and Hour Division, all the different sides, also from being an employer, and putting them together to try to bring you some insight into recommending how I might go ahead and roll this out. And we're going to roll it out to you today, give you some instructions on how we have advised our clients to go ahead and roll this out. So with that, I want to go on to the first slide. So the Notice of Coverage Options is this form that we have to provide, or notification we have to provide to all of our employers. All of us employers have to provide to our employees by October 1st. So the first thing we want to know about this is a mandate under the healthcare reform, and the purpose of this is to allow our employees to know that there is a new option out there to get coverage. It's called the Health Insurance Exchange, which we also refer to now as the marketplace, and that is the new term that you'll see used by the federal government. So what exactly is the rule? Well, the Affordable Care Act requires that all employers who are subject to the Fair Labor Standards Act issue a notice regarding the exchanges to their employees no later than March 1st, 2013. And as you can see, that was delayed until October 1, 2013, when they issued an FAQ on January 24th, 2013. So what we want to do here, first and foremost, is to make sure that you're comfortable as we define each of those different areas, 1, 2, 3, and 4, and give you some guidance on actually getting that out to your employees. So the Notice of Coverage Options states that employers subject to the Fair Labor Standards Act must comply. So I wanted to give you a little bit of an excerpt on what employers are subject to the Fair Labor Standards Act. These are employers who have one or more employees who are engaged in interstate commerce. Now, interstate commerce means that you sell things to people in different states. Also, it has been broadly interpreted to include accepting credit cards, because credit cards are considered interstate commerce. I did run by our attorney knowing that I was doing this webinar. I said, boy, what about auto dealers? And he said, boy, Kate, cars are about the most mobile thing we have. And I believe the DOL would construe that and interpret the sale of cars to be interstate commerce. So, of course, welcome to run that by your legal counsel, but that was the question I had asked mine and his interpretation. It is only subject if you've got $500,000 or more in annual dollar volume, which would be sales in your business, and it specifically covers some different entities, which you are not one of, but that is just up there. In case you're not sure, just through that description, whether or not you're subject to the Fair Labor Standards Act, I went ahead and gave you a website here, and there is it's on the Department of Labor website, and there is basically like a tutorial type of thing where you answer yes or no, and it will take you through to tell you whether or not you're subject to the Fair Labor Standards Act. You can also call them if you're unsure, and they will help to assist you in determining that. But if you are subject to the Fair Labor Standards Act, you will be subject to the requirement to provide this notice of coverage options to your employees. So the next thing we want to review is what exactly needs to be included in the content of the notice. Now, there was a technical release issued that told us the requirements for the notice, and basically it must inform the employee of the existence of the marketplace, including the contact info for the marketplace, which is merely a link, healthcare.gov. I believe we provided it in the model notice we're going to go over. There's also, you must inform the employee that they may be eligible for premium tax credit if they purchase qualified health care through the marketplace, and also notify the employee that if they go ahead and purchase the coverage through the marketplace, the employee may lose the employer contribution to help the health plan that you offer, and all or a portion of that contribution that you give them is excludable from income or federal income tax purposes. Federal income tax. So if you know the amount of contribution you make for any employee is a tax-favored benefit, you're able to give it to them without them having to pay income tax on it at this time. So that's one of the biggest benefits to employees, is that this is a tax-favored benefit. We also recommend that you include a statement on minimum essential coverage and minimum value, and that's to go ahead and keep a lot of questions from people from lining up at your door with questions. Minimum essential coverage is basically a group health plan, and by offering a group health plan, it would be determined to be minimum essential coverage. If you offer a plan in the small group market being under 50 employees, you have to offer something called essential health benefits to have minimum essential coverage. But if your plan starts on or after 1/1/2014, then your plan will have to have all of those essential health benefits as they're dictated. If you have more than 50 employees and you offer a group plan, it's minimum essential coverage. If you have a plan renewal date that is other than 1/1/2014, other than January 1, you might want to check with your employee benefits broker or consultant and just confirm that your plan is minimum essential coverage, but it should meet those qualifiers. The other thing is minimum value. Under the law, we have to provide our employees not to have a pay or play penalty, which we can talk about when we speak at the conference, a plan that's worth at least 60% actuarial value. Most plans are worth 60% actuarial value in the group health benefit market, but you want to also make sure you check this with your consultant and ask them what is the actuarial value or the calculated value of the plan you offer. If you go up to this www.dol.gov/EBSA, over to the right-hand side there is a calculator, and you can put your plan in as well, and you can get a value calculation on your plan. But we do recommend that you include this statement because this will help employees when they want to go apply. It'll help the person working with them to know whether or not they're eligible for a subsidy, because if you offer minimum essential coverage and minimum value coverage, your employees are not eligible for a subsidy. So the other thing we want to talk about is, when we're talking about the content of the notice, is that the DOL has provided us 2 model notices, and we are big believers in trying to keep things simple, and why recreate the wheel when they've already given us model notices. So we would recommend that you use these model notices. The first model notice is for employers who do offer a health plan to some or all employees, and there is a separate model notice for employers who do not offer a health plan to their employees. And we provided you the website so that you could access these model notices. Please note that they're offered in a Word fillable form format, and they are also offered translated into Spanish. One of the things that's very important is that they have the standard of offering information through healthcare reform in a manner that is culturally and linguistically appropriate. And they have provided us a list actually of all the counties in the United States that we have to list in class format. I provided you the actual website to find that information. And also at the bottom, I have offered for you or provided for you the counties that are Spanish-speaking in Florida. The Spanish-speaking, Florida only has a class mandate with regard to the Spanish language, though other states have different ones. and these are the actual class Spanish-speaking counties. So if you have a business in these counties that's done by business situs, you need to provide this to your employees as well in Spanish as well as English, or tell them where they can find a Spanish version. You can access, again, these model notices at the link above, and you may use these model notices or a modified version, provided that the notice meets the content requirements that we've described on the prior slide. So what exactly is in the content of the notice? Well, again, we wanted to show you the actual model notice. Now, the model notice for employers who do offer a health plan to some or all employees is a 3-page document. The first part is Part A. This Part A contains those 3 required elements that we reviewed on the previous screen. Part B is a 2-page document. The first page is plan information, employer information, and who is covered under your plan and whether or not it offers minimum essential coverage, and minimum value coverage. Page 2 of Part B, for employers who do offer a health plan, is actually more employee specific. And this information, we believe, will bring a lot of questions to your door, but you are, of course, this is optional for you if you want to go ahead and complete it. There's also a model notice for employers who do not offer a health plan to some or all of the employees. And this is just a 2-page document, Part A, Part B, and it's very straightforward. Part A is actually the same as the other document. What's different is Part B. Part B just has some basic employer information. So with regard to both notices, just so that you can get some comfort on how they have worded the required information, both of the notices are, again, the same for Part A. What is the health insurance marketplace? This takes care of explaining to employees the existence of the marketplace and the description of the services provided by the marketplace, and the contact info. If you see there, it says healthcare.gov. That's where they go for the contact info. It also answers the question whether, or tells them that they may be eligible for a premium tax credit. You can see this boxed information is directly excerpted from the model notices. And the third required element, where it tells the employee that if they purchase coverage through the marketplace, they may lose the employer contribution and the tax benefit, is included in the model notice in this portion that we've highlighted here and excerpted here. So Part A fulfills the 3 mandated notice inclusion requirements. We also recommend that you either include either a cover letter or Part B to include a statement on the minimum essential coverage and the minimum value. Okay? You know, we ask our employers, do you want to include Part B? You know, if you do not offer coverage to your employees, I definitely include Part B. It's very straightforward. If you do offer coverage to your employees, Part B, page 2 is a lot of work and information. So our recommendation would maybe to include one of these 2 options. Include Part A of the model notice and a cover letter, which we're going to review in a second, which includes a statement on minimum essential coverage and minimum value, or include Part A and Part B, page 1, which has that disclosure on the minimum essential coverage and the minimum value, and then the cover letter becomes a little more optional. But you could still include it. It depends on how you want to do it. And as I was just speaking to one of my clients, this cover letter, which we have given you an idea of a draft of a cover letter you might want to use here, can be tweaked to your liking, to your culture, to be indicative of how you would say things. We've just wanted to provide you a draft of something to make it easy. Again, it may add a minimum essential coverage, minimum value statement. Anything in this draft that we've provided you in blue would need to be updated by you, okay, because it's very specific to your organization. And that includes that statement on the bottom that this plan meets minimum value standard and the cost of this coverage to you is intended to be affordable based on the employee's wages. If you notice, that is exactly from page 1 of Part B of the statement. So, you know, again, if you don't provide any coverage, just give them A and B, and I don't even think you need a cover letter. So of course, you have full freedom to go ahead and update this. If you do offer coverage, you can use one of those 2 options we discussed, which includes this cover letter. So the biggest question we thought you probably are all wondering is, what employees must receive the notice and how do I get it to them? So you must provide this notice of coverage options to each employee, regardless of whether or not enrolled in your plan and regardless of whether or not they're part-time or full-time. Okay, you're not required to provide it to their dependents and spouses. This is different than the summary benefit and coverage, which needs to go to them, and not required to be provided to retirees or COBRA participants because they're not employees. When is the coverage, the notice due to the employees, and how can it be delivered? Well, as we stated earlier, it is due by October 1st to all of your employees, and it must no later than October 1st. It must be provided automatically, free of charge, to all current employees, including part-time, seasonal people, full-time people. All employees must receive this notice. If you hire somebody between October 1 and before December 31, you want to make sure you're giving it to them with a new hire package. After October 1 or after 2014, you want to make sure you give it to them within 14 days of an employee's start date. Now, it must be provided in a manner calculated to be understood by the average employee and in a manner in which it is reasonably believed that they will receive it. So the safe harbor is to mail it by first-class mail. But you can alternatively provide it electronically if your employees, if you meet the Department of Labor electronic disclosure safe harbor. Just to give you an idea of what that says, here it is. And basically, if your employees are required to look at their email on a consistent day as part of their work, every day as a consistent part of their work, as an integral part of their duties, you will likely fall under the safe harbor, and you can send it via email to them. Now, just to give a little recap on this, and just to speak a little more on a delivery option, another delivery option might be to provide it with people's paychecks. If you choose this option, you just need to make sure that you are still providing it to part-timers or seasonal people who are still technically employed with you but did not receive a paycheck for that period. And you also want to make sure that you are distributing it to them if you have auto pay where everybody doesn't come and pick up their stubs, and that's very common. That might not be the best way for you to send it to them. Okay? There's other ways to send it to them. You can do a list of all employees and ask them to sign off that they received it. Keep that documentation with a copy of your cover letter and your notice in your files in case you get asked, did you give that out? Yep, this is what I did. This is the process and procedure I followed. But just make sure, you want to make sure that, you know, it's reasonably calculated that the employee will receive this information. Okay? So just to give you a recap, prepare the required notice information for employee distribution. Decide if you're going to use Part A, and Part B. If you elected, if you have a plan, Part A and B. If you don't offer a plan, Optionally, prepare that cover letter and letterhead for inclusion. You can go ahead and modify it. This is just a draft I'm providing for simplicity purposes for you. Send it to your current employees, not retirees, not terminated employees on COBRA, by October 1, 2013. Send it by mail. Send it attached to the pay stubs. Keep in mind this discussion that we've had along the way through this webinar. Select an as-of date that you're going to perform this function. I'm going to perform this as of the pay date on September 20th. Okay? Anyone that you hire after that, make sure you add it to their checklist. If you have an acknowledgement form with your new hires where they sign off, yeah, I got my handbook, yep, I was told about my HIPAA rights, yep, you might just want to go ahead and add this to that checklist. But you will make sure you put in your new hire package for anyone after your as-of date. And keep copies of your model notice of coverage with your cover letter, if you used one, with your Part B, if you gave it out, in your HR benefits office, and make sure you provide it free of charge upon request, okay? And also make sure you keep a documentation in your records of exactly how you decided to distribute it, in case the Department of Labor ever pays you a visit, or you get a request, or you get somebody who goes to the exchange, and because we're part of the federally facilitated exchange here in Florida, they may reach out to you as an employer and say, we want to validate that this employee is eligible for a subsidy, and you would have this model notice right there. And even if you don't give the information out, you might want to keep a copy of it for your records, just to have it in case you get one of those phone calls. Okay, you might also want to keep a schedule with all the co-share and co-payments, because there are definitely strategies out there, especially if you're in the small group market and you have people that don't make as much money, to allow your employees, because you're not subject to the pay or play, to allow your employees to have what we would consider unaffordable coverage and still be able to be eligible for a subsidy. So again, my goal today is to make sure that you're aware of this requirement, that you have an idea on where to find the model notice, a recommendation on how to get this distributed out. Please make sure you're consulting with your employee benefits advisor or consultant with those questions on minimum essential coverage, minimum value. Get their input and recommendation if you're unclear or have a question, because obviously they are your advisor. And I also wanted to invite you all and tell you I look forward to meeting you at the Affordable Care Act panel to be held at the upcoming convention at the Disney Coronado Springs Resort on Saturday, October 19th. I will be part of a panel joined by two other colleagues at 10:45 a.m., and I am very much looking forward to seeing you. We did want to give you this webinar ahead of time because obviously this requirement is coming up before the October 1 due date. So, I'm sorry, the October 1 due date is before this October 19th panel discussion and conference. So I hope this has been helpful. Here is my contact information, and I'm going to sign off and wish you all a great day and tell you I'm looking forward to meeting each and every one of you at your conference.